Probate in Ontario, then and now. Welcome to Tea at Taxevity, where you get insights from insiders, our many clients and friends. I'm Pramod Sharma, the actuary at Taxevity. I help people who care about sustainable financial independence harness the power of life and health insurance. Our guest is Kathryn Bennett. Kathryn, what do you do when you're not being interviewed?
I am a trust and estates lawyer by training, and I work in the financial services industry. So I'm not in traditional private practice.
We're talking about probate in Ontario. First of all, what is probate?
Oh, always a good question. Probate is a court process where essentially the court confirms that the person who is your estate trustee, that's the term in Ontario, it's executor elsewhere in Canada, liquidator in Quebec, that person that they confirm has the legal authority to deal with your estate, basically gathering in all your assets, paying debts and taxes, and then ultimately distributing the assets to your beneficiaries. So the process of probate is where the estates court, probate court in other provinces, it has different names, says this is the person with the legal authority. So third parties, Canada Revenue Agency, for example, knows that the estate trustee is the person that they deal with.
When did the rules change in Ontario?
Well, the provincial government introduced some changes. They said they were going to make the changes in the 2011 budget. The legislation was passed in 2013. The new rules are fully in effect as of January 1st of 2015, so this year. And the change is really to how estate administration tax, which is the amount that the province charges on the value of an estate for probate, how it is administered, collected, audited, verified. That process has changed. The rest of the probate process has not.
Okay, because the sense I'm getting is that a lot has changed, but it sounds like that may not even be the case.
That's actually, yeah, that's accurate. There's a lot of there's been some media coverage recently that is a bit confusing, I think, for the average reader. And it's in part because there's kind of some misinformation and a bit of almost scaremongering. You know, we want to scare people into, looking at their estates. My personal view as a professional is that, well, we should all be reviewing our estate planning on a regular basis.
Mm-hmm.
So if the scaremongering or the misinformation leads someone to review their estate plan, that's probably not a bad thing. So, but what has changed again, as I said, is it's really, what we've done is we've shifted. In the past, the estate administration tax, called probate fees, it isn't, it's a tax, but it's often called probate fees, was collected and administered by the Attorney General's office. The Attorney General's office is in charge of the estates court.
Okay.
Okay. What's changed is the collection, auditing, verification, and everything's now been shifted to the Provincial Minister of Revenue.
Oh, okay.
So, yeah, so it's being administered just like any other provincial tax. Think retail sales tax.
Mm-hmm.
Okay, so it's now actually with the provincial body where it really makes a lot of sense for it to be. It's a tax. It should be with the Minister of Revenue. And that's the part that has people very kind of concerned because it's now being fully administered as a tax. The rules are more complex. It's more onerous on the estate trustee. And the key date is probate, the grant of probate, the certificate of appointment of estate trustee that's issued after January 1st of 2015.
Mm-hmm.
The new audit and verification regime applies. If your certificate of appointment was issued before January 1st of this year, you're under the old rules.
Okay.
So, and one of the misunderstandings is, how soon do I have to file that first estate information return? So it's 90 days after the date that the certificate of appointment of estate trustee is actually issued.
Okay, so not 90 days after death.
Exactly. It's 90 days after the date that the certificate is issued. And the certificate of appointment isn't issued right away. There's a process. Again, this is the probate process. So the estate trustee has to apply to the estates court for the certificate to be issued. And part of that whole process is gathering some information about the deceased, filling out a bunch of forms, paying the initial estate administration tax levy. And depending on where you are in the province, because there's more of a backlog in highly populated areas like Toronto, there's less of a backlog at times for getting probate applications through in other parts of the province. So it could be weeks or sometimes even a couple of months, several months after a person has passed away before that certificate is issued. Then the estate trustee has 90 days from that date.
Okay, is there something else notable that's changed with the new rules?
Oh yeah, audit and verification. So there's a lot more information gathering that the province is now going to do about the deceased and about their assets. So they're going to want to know what assets are actually part of the estate. So everything that the deceased owned in his or her own name, not things that go by way joint with right of survivorship, meaning the surviving co-owner now owns the asset. Not things that you're a beneficiary of another trust, not those kinds of things. The things that you personally own. The other thing that's not part of your estate are the things that you've done, given away by way of beneficiary designation. So typically life insurance, RSPs, RIFs, tax-free savings accounts, things like that can go outside the estate if you've done beneficiary designation planning. So the province is gathering all this information, and they're charging estate administration tax based on the value of the assets that are part of the estate. It's $5 for the first per $1,000 of value for the first $50,000 of value. Then it's $15 per thousand for everything after that with no cap.
Okay.
So the first $1 million, you're an actuary, you'll do the math very quickly. The first $1 million is $14,500. Every million after that is $15,000 with no cap.
Okay, so it can become a fairly sizable amount.
Well, on a $5 million estate, it's close to $75,000 in estate administration tax. So people are, because of this change, I think a lot more interested now in doing effective probate avoidance planning. And we need to be careful that we do probate avoidance, not probate evasion, because tax evasion is bad, tax avoidance is okay. So, and part of that verification process is you need to be able to tell the province what an asset is worth. How do we do that? We get it appraised.
Okay.
So one of the big changes now will be valuations will become really important. A lot of estate trustees would kind of make an estimate, and it was a best efforts estimate. And that was okay because they weren't being expected to validate that amount. Now we're being expected to validate the amount. So one of the changes will be estate trustees in that 90 days between when the certificate is issued and when they have to file the estate information return will be getting official appraisals done.
Okay.
So like a real estate agent, they're going to want to pay probably to have that appraisal done because the real estate appraiser is now kind of on the hook, if you will, for saying, yes, this is the actual amount. I'm qualified as an appraiser. This is the amount. Here's your written valuation report. So that verifying amounts of what is in the estate become really important.
What hasn't changed?
Oh, well, most of everything else.
Okay.
So the process of applying for probate, that's the estate trustee goes to the estates court. Typically they get help from a lawyer or a qualified paralegal to fill out all of the forms because there's a bunch of different forms that have to be filled out. They take those forms, including your death certificate, and apply to the estates court for the certificate of appointment. That whole process hasn't changed. The process by which the court reviews the documents and issues the certificate of appointment, that hasn't changed either.
Okay.
So that's all the same. The then is still the now, if you will.
Okay, that's good to know because I was getting confused because it sounded like so much was changing and I didn't quite understand what was happening.
Yeah, and it's more at that back end. It's the audit and verification part, and that's the other, Yeah, that's the scary part though, because now there's penalties as well. If you misrepresent, if there's fraud, if there's mistake, if there's carelessness, it's just like with your tax returns. Um, the provincial minister of revenue can do an audit and there can be penalties and interest. So the estate trustees a lot more invested in making sure they're getting it really, really right in terms of the numbers. But how you get probate hasn't changed. The other thing that hasn't changed is, the cost. I mentioned earlier that the cost is that $5 per thousand for the first 50 and $15 for every $1,000 thereafter. That amount hasn't changed. Now, the province can change that amount at any time.
Which they could have done in the past also.
Which they could have done in the past. And typically, if they change the amount of the estate administration tax, it's done on relatively short notice. They notify, the members of the public, the legal community, the estates court, that the amount has changed as of a given date, and we simply carry on. So the amount hasn't changed, the process hasn't changed. It's this whole audit and verification regime that really, I think, will impose a lot more care and caution on the part of estate trustees. There will be more expense because people will be obtaining formal valuations. If, for example, someone has a group of 7 painting, collection, a group of 7, they're going to want to be really, really clear on the valuation for estate administration tax purposes. They're also going to really want to know for capital gains tax reporting purposes for, the Canada Revenue Agency. But audit and verification is really where the issue is going to be. And if you lie, or if there's fraud or a mistake or carelessness, you could, as an estate trustee, be subject to penalties.
What happens if a person doesn't have a will?
Well, yeah, like about over 50% of adults, and I'm downplaying that number.
Oh, it is that high?
It's closer to over 60%, depending on the province and depending on the age of the individuals. A lot of Canadians think that a will isn't really a terribly important document, or they procrastinate. Some people think if you do a will, you're going to die right away, and the bad news as an estate lawyer is you die anyway, with or without a will.
Okay.
So if you have a will, the application for probate is just simply easier because you have this document that can be submitted to the court.
Okay.
And that document then becomes the guidelines by which the estate trustee handles the administration of the estate and sets out who ultimately receives the assets, the beneficiaries of the estate. If you don't have a will, the province decides for you. So part of that process would be there's a list of people under the Estates Act who are eligible to apply to become your estate trustee. The province also sets out the regime that determines who gets your assets, whatever goes through your estate that you didn't do by beneficiary designation or joint ownership with right of survivorship. So there's a regime that sets it out, and it's based on: are you legally married? Are you living common law? Do you have children? Do you not have children? Do you have any family members at all? And so it can become disturbing for people when they realize that often, if they don't have a will, people that they would not want to have inherit, people that they would perhaps not want to have be their estate trustee, are the people who in fact may apply. So that's one of the things that hasn't changed, but I am kind of hoping that the change in the probate administration, the collection and administration of the estate administration tax, I'm kind of hoping actually that it will inspire more people to go out and actually have wills and powers of attorney for property and personal care done. The one little side note for anybody who's not in Ontario who thinks, well, this is just Ontario, the other provinces are watching, because any province that has a deficit, estate administration tax or probate fees or whatever they may call it, is a very easy, cost-effective way for the province to collect money.
That's a really good point.
So by shifting it to the provincial minister of revenue, treating it like any other provincial tax, it becomes one more revenue stream that's relatively easy to administer because everybody dies. Relatively easy for a province to collect and administer. So provinces that maybe historically have had low costs for probate are now actually watching what's going to happen in Ontario.
What's your key message for the people watching today?
Probate planning is really about, to be blunt, it's what happens to your stuff after you die. And if you care about your family, your loved ones, your favorite charities, you will go out and you will do a will. And you will do it ideally through a qualified legal professional who will walk you through the process of estate planning, ask a lot of questions, help you decide how to do this, and then put it all together in a formal will that will make things easier for your estate trustee and ultimately for your loved ones after you pass away.
What's the best way for people to reach you?
Easiest way is through LinkedIn. That's the easiest way to do it.
Thanks very much for dropping by. Thanks for joining us for Tea at Taxevity. The Taxevity Insurance Advisory helps you understand insurance and bridges gaps in your coverage. There's no premium for peace of mind. How healthy is your insurance?